Namaskar, friends. First of all, I would like to welcome CA Advocate Divyanshu Agarwal. Divyanshu ji, welcome to you.
Namaskar.
Myself, Sumit Garg, once again, welcome to you in this Team Casa platform. And one of the important burning issue in income tax case study we are going to discuss. Himanshu ji, one of the common problem is when we file the return of income, having refund in the same. As per the provisions, the department is supposed to process the refund after 143(1) intimation within 6 months. But practically, we have seen that they have not processed the refund and withheld refund on the ground that 143(2) notice issued. Is it correct position? And on which ground of the case law we can challenge this? So kindly enlighten on this topic. So over to you, Divanshu ji.
Thank you so much, Sumit. Thank you, Team Casa, for inviting me again. Thank you. This is a very good topic, Sumit, and everybody is actually facing the problem. So it is equally very important to understand what is the provision in the income tax department about withholding the refund. So before we start, let us see the background of withholding or refund. First, there was a section called Section 241, which was omitted with effect from 1st June 2001, wherein this type of provision was there in the income tax statute, wherein the department has the power at that time to withhold the refund on the ground that if it is adversely affecting the interest of the revenue. So there is certain ingredients which was there in Section 241 at that time. That was omitted with effect from 1st June 2001. So subsequently, another provision, another section which was inserted in the Income Tax Act 1961, White Finance Act 2012 was subsection 1D of section 143 of the Income Tax Act. This was introduced in 2012, but this provision was little more stringent, wherein the power was given to the concerned officers not to even process the return under section 1 for subsection 1 of section 143, and they can withhold the refund in case of the notice has been issued under subsection 2 of section 143 2. So what was happening in that section, the trade bodies are facing a lot of problem. Take an example, sir.
Divanshu ji, can you share the PPT? It is not reflecting.
So I'm just discussing
Okay,
this
okay,
coming, sir.
sure. Okay, sure. Yes, it is clear.
Yes, I'm just going into the background, sir.
Sure, sir.
So there was subsection 1D of section 143, which was introduced in Income Tax Act 1961, White Finance Act 2012. The provision of that section was little stringent, wherein the concerned officers has the power not to process the refund, not to process the return under subsection 1 of section 143 of the Income Tax Act in case they have issued scrutiny notice, which is under subsection 2 of section 143 till the assessment has been concluded. So what the problem the trade bodies was facing at that time was, in case if some amount of refund is coming, so instead of getting that refund, they need to wait till another 2 to 3 years for the concluding of the assessment. So they were facing a lot of financial problem in due to this provision. So White Finance Act 2016, the government has introduced a new section, which is section 241A of the Income Tax Act. This section was effective from assessment year 2017 and 18. So, sir, this was a section 241A. So, the judgment which we are going to take in is on section 241A, which is effective from assessment year 17-18. Sir, first of all, let us see the language of section 241A to understand what is the law in section 241A. For every assessment year commencing on or after the 1st day of April 2017, which is effective from assessment year 2017, 18 and onwards, where refund of any amount becomes due to the assessee under the provisions of subsection 1 of section 143. And the assessing officer is of the opinion having regard to the fact that a notice has been issued under subsection 2 of section 143 in respect of such return, that the grant of refund is likely to adversely affect the revenue. This is one of the very important ingredient of this section. Is issuing a refund is going to adversely affect the revenue? Number one, this is one of the very important condition which the assessing officer has to showcase. And then based on that, the assessing officer is supposed to apply his mind legally, and then they are supposed to record the reason, which is there in the provision, that he may, for reasons to be recorded in writing. And not only after recording the reason, they need to take in prior approval of the principal commissioner or commissioner, as the case may be, to withhold the refund up to the date on which the assessment is made. So friends, what happened? Some of the language is very common to the language which was there in section 241 of the Income Tax Act, which was omitted. But I must say one thing, 241A has more narrower meaning, and the government tried to reduce the discretionary power of the assessing officer, because having an ample discretionary power is always the problem. So they have tried to reduce the discretionary power. So friends, 2-3 things which is very important to know about this provision is, first, this is only applicable for assessment year 2017, 18 and onwards. This is the only provision effective. Number two, in this provision, the government has given the power that the assessing officer is mandatorily supposed to process the return under subsection 1 of section 143, friends, which was not there in the earlier section in the previous assessment years under subsection 1D of section 143. And in spite of that the notice has been issued under subsection 2 of section 143, first very important ingredient, the assessing officer has to see that whether issuing a refund is going to adversely affect the revenue. They need to apply their mind, they need to record the reason in writing, and based on their findings, they need to get an approval of the principal commissioner. So there are a lot of checks and balances in this section. So they cannot blanketly apply to 41A and withhold your refund. One thing which is very important, in case if there is any problem, the only route, there is no alternative remedy. If you would like to challenge this thing, you only have a provision under writ. You can go under Article 226 and 227 of the Constitution and file a writ. Under 246A, there is no such provision to file an appeal against 241A. As we all are aware, what does subsection 1 of section 143? When we file a return, friends, under subsection 1 of section 139, or we file a belated return, or we file a revised return, the CPC, Central Processing Center, they process the return, first of all, under subsection 1 of section 143. So if there is any demand is coming, they'll come out with a demand. If there is any refund is coming, they process it and then they'll come out with a refund. If you see clause E, which I have highlighted in red, the relevant extract of the section is the amount of refund due to the assessee in pursuance of the determination under clause C shall be granted to the assessee. And the second proviso, if you see, provided further that no intimation under this subsection shall be sent after the expiry of 1 year from the end of the financial year in which return is made. So the timeline, the last timeline for issuing a 143(1) intimation is, for an example, friends, you have filed your return on 31st July 2019. That means the financial year is closing on 31st March 2020. So the last date of issuing 143(1) is 31st March 2021 for financial year 1920. In case of assessment year 1920, friends. So now a very good question raised by Sumit ji, which every professional friends are facing. The issue involved is whether withholding or refund under section 241A, which we have mentioned just now, discussed, pursuant to notice under subsection 2 of section 143 without recording reasons justifiable without recording justifiable reasons is sufficient, justified or not. Interestingly, friends, a very good and very important decision observed by Honorable Delhi High Court pronounced in October 2019 last year in the case of Maple Logistics Private Limited and another versus Principal Chief Commissioner of Income Tax and others. This is related to assessment year 1718 and assessment year 1819, which in those assessment years, section 241A is applicable. I believe this is reported in 420 ITR. I'm missing the page number, but it is reported in 420 ITR, this judgment. So let us see very categorically. The brilliant part of this judgment is the Honorable High Court have seen the facts of the complete case. They have heard the arguments of both the sides. They have analyzed the judgment to the extent they have gone into the history of refund. They have seen what was there in section 241. They have seen what was the judgment affecting 241, wherein the honorable courts have analyzed the meaning of adversely affecting the interest of the revenue. Then they have seen subsection 1D of section 143, and then they have come to 241A. They have seen the definition of 241A, applying the same section on the facts of the case. The honorable court have seen the reason recorded by the department. They have seen the approval taken, and they have seen the 241A order pronounced. And then based on that, they have given a very beautiful observation and they have given a decision on the same. So I'm coming to, let us see what is the facts which was before the Honorable Delhi High Court in the case of Maple Logistics. Facts of the case. Petitioner, which is the name of the party, filed its return of income for the assessment year 1819 on 29th October 2018, claiming refund of rupees 1.43 crore on account of excess deduction of tax at source. This is one of the major reasons of refund in your return, when there is always an excess TDS. So revenue selected the case of the petitioner for limited. As you are aware, there are limited and comprehensive scrutiny. So in this case, there was a limited scrutiny under subsection 2 of 143. Reason was large refund of the act, wide notice dated 22nd September 2019. Subsequently, the Centralized Processing Center processed the return of income under subsection 1 of section 143, which resulted in refund of around 1.57 crore in this case. Now, the problem comes. Your return has been processed, amount has been determined, but you're not getting the refund. This is a problem of everybody. So in this case, the petitioner submitted various representation dated 29th November 2020, 16th December 2019, and 17th December 2019 in this respect. 3 representations were done from the petitioner's side to the department asking for the reason of withholding the refund. So based on that representation, the department has given a personal hearing to the petitioner. So during the personal hearing, for the first time, friends, it was informed to the petitioner that the refund has been withheld under section 241A of the act. Okay, but neither they have provided the copy of the reason for the refund, withholding the refund, nor they have provided the copy of 241A order in this case. So after that, there is no alternative course or remedy left for the petitioner. So after trying a lot with the department, so the petitioner moved and filed a writ petition before Honorable Delhi High Court. During the writ hearings, friends, department supplied the reason for withholding the refund for the first time to the petitioner. So obviously, the petitioner has amended the writ petition, and then the argument has been started. So the direction which the petitioner is taking in this writ petition is seeking the direction to the respondent, which is the department, to refund the income tax amount, which is on account of excess deduction of tax at source in respect of assessment year 1718 and 1819. Issue for consideration before Honorable Delhi was the question that arises for consideration in the present case is as to the scope and ambit of the newly inserted provision. What is the scope? What is the ambit of this section of 241A? What are the powers given to the department under section 241A? Can they withhold any types of refund, or do they have any checks and balances in the section? So the very interesting part is that this was one of the first decision wherein the Honorable Court has analyzed section 241A, the Delhi High Court. Friends, let us see what are the very important observations of the Honorable Delhi High Court. It is now mandatory to process the return under subsection 1 of section 143 and proceed with grant of the refund determined therein unless sufficient reasons exist under section 241A showcasing that the grant of refund is likely to adversely affect the revenue. However, in the newly inserted section 241A, adverse effect on the revenue is the sole ground for such withholding. So adverse effect on the revenue is the only ground which is there in 241A. That too subject to recording of proper reason after applying your mind and taking a prior approval from the principal commissioner or commissioner in the same. So the Honorable High Court have seen the intention of introducing section 241A simultaneously with the insertion of the aforementioned proviso was to address the grievance of the SSE relating to delay in issuance of refund in genuine cases which are routinely selected for scrutiny assessment. So what happened generally in many of the cases that are genuine cases, but just because on the sake of issuing a 143(2) notice, the department never process your refund. So that is the whole idea of this section, not to affect the genuine people. However, at the same time, that to address the concern of recovery of revenue in doubtful cases, the legislature introduced section 241A, which enables the assessing officer to withhold the refund in favor of the assessee, which becomes due in terms of subsection 1 of section 143. So if he is of the opinion that having regard to the fact the notice has been issued under subsection 2 of section 143, the grant of refund is likely to adversely affect the revenue. So after that, one ingredient, second ingredient, he would however do so by recording reasons in writing. And third important element is taking a previous approval of the principal commissioner and commissioner and withhold such refund till the date the assessment is made. These were certain observations of the Honorable High Court on section 241A. So Honorable High Court has given a decision in this case. The language of section 241A envisages that the aforesaid provision is not resorted to merely for the reason that the case of the assessee is selected for scrutiny assessment. Sufficient checks and balances have been built in under the said provision and same have to be given due consideration and meaning. An order under section 241A should be transparent and reflect due application of mind. This was one of the decision of the Honorable High Court. So the discretion vested with the AO exercised judicially and is conditioned and channelized merely because a scrutiny notice has been issued should not weigh with the AO to withhold the refund. They cannot withhold the refund just because they are for the sake of issuing a scrutiny notice. The AO has to apply his mind judicially, and such application of mind has to be found in the reasons which are to be recorded in writing. He must make an objective assessment of all the relevant circumstances that would fall within the realm of adversely affecting the revenue. Friends, these are very important paras and very important lines which was there in the Honorable High Court decision, which we have to keep in mind in our case only before analyzing whether we are going to file a writ in this case or not. Are this case fit for writ or not? The fact that notice under subsection 2 of section 143 has been issued would obviously be a relevant factor, but that cannot be used to ritualistically deny refunds. They cannot blindly and ritualistically deny refund like this. So the AO is required to apply its mind and evaluate all the relevant factors before deciding the request for refund of tax. Such an exercise cannot be treated to be an empty formality and requires the AO to take into consideration all the relevant factors. These were the observations and the decisions of High Court. So finally, the High Court has held in this case is merely because a notice has been issued, it is not a sufficient ground to withhold refund, and the order denying refund on this ground alone would be laconic. Additionally, the reasons which are to be recorded in writing have to also be approved by the principal commissioner or commissioner, as the case may be, and this should be done objectively. So friends, just the department has issued one for subsection 2 of section 143(2) is not sufficient. They are supposed to showcase the reasons properly recorded in writing after application of their mind, and then after taking a previous approval of the principal commissioner. And just for this, in case if you find the reasons recorded is we have issued this notice only, that is a reason they believe that that is adversely affecting the revenue, this is a good case to challenge before the Honorable High Court in a writ, because that is not a sufficient reason. And in case if the principal commissioner or the commissioner jurisdiction has given an approval on that simple reasons, yes, that is not the purpose and that is not the objective of section 241. After this decision, friends, some of the case laws which was there was, number one, 18 February 2020, one of the decision was pronounced by Honorable Delhi High Court, which was in the case of Ericsson India Private Limited versus Additional Commissioner Income Tax. This was pronounced on 18 February 2020. I believe Ericsson was also is reported in Taxman. And latest decision following these two decisions of Maple Logistics and Ericsson was Pune Institute of Healthcare and Research Center Private Limited versus Income Tax Officer Ward 63, which was pronounced by the Honorable Delhi High Court on 27 July 2020. This was also reported in Taxman. So Maple was reported in ITR, and Maple, Ericsson and Pune, all the three decision was also reported in Taxman. Simultaneously, friends, there was one decision which was pronounced in February 2020 by Punjab and Haryana High Court, Honorable Punjab and Haryana High Court, on a similar issue following Maple Logistics decision. So I have one slide on the important findings in Ericsson case by the Honorable Delhi High Court, which is important for us to know. This was the important finding in Ericsson by the Honorable High Court. The refund of amount claimed where they appear justified by itself cannot be said to be adverse to the interest of the revenue. The interest of revenue lies in collecting revenue in a legal and justified manner. It does not lie in retaining the collected taxes in excess of what is justified, since the excess collection cannot even be properly termed revenue. The excess collection of tax is a liability of the state, and it lies in the interest of the revenue of the state to discharge its interest bearing liability without any delay. The sovereign cannot but be seen as fair, honest, and credible in its dealing with its subjects. Any lapse in this regard tarnishes the image and credibility of the sovereign. It certainly cannot act like any unscrupulous businessman who is seen to dodge his liabilities by resort to frivolous excuses in devious ways. This was the para which I have picked from the Honorable Delhi High Court decision in the case of Ericsson. This was a finding in the Ericsson decision by the Honorable Delhi High Court. So friends, ultimately, the ratio which is coming from these decisions of Maple Logistics, Ericsson, Pune Institute, Punjab and Haryana High Court decision, one of the decision pronounced by Honorable Bombay High Court, was merely because a notice has been issued under subsection 2 of section 143 is not a sufficient ground to withhold refund. And the order denying refund on this ground alone would be laconic. And the reasons which are to be recorded in writing have to be approved by the principal commissioner or commissioner, as the case may be. And this should be done objectively. Thank you so much. Thank you. Over to you, Sumit.
Thank you, Divyanshu ji, for wonderfully enlightening our judicial pronouncement in this case, particularly in what ground refund can be withheld by the department. And thank you very much for your wonderful insight on the cases. Thank you to you. Thank you.
Thank you
Namaskar.
so much, Sumit. Thank you, Team Kasa. Thank you.